Welcome everyone. Today in this short video, we're going to explore how a pre-existing condition affects a new workplace injury claim. It's very common for a workplace accident to result in an injury to a body site that has had a previous injury. I'm Rebecca Johnson. I'm Fine Olin and Anderman's Upstate Labor Liaison, and I'm here today with attorney Howard Lipman, who is a lawyer for workers' compensation here in Buffalo, New York. Welcome.
Good morning.
Good morning. Let's get into it. So let's start off with, does a prior injury affect a new injury claim?
Well, the short answer is yes, but it's important to remember that having a previous condition does not prevent an injured worker from obtaining workers' compensation benefits from a new injury to the same body site. The important question is, did the workplace accident result in an aggravation of the pre-existing condition? As with all workers' compensation claims, the burden is on the injured worker to establish that the current disability is a result of that workplace accident.
Okay, could you define exactly what you mean by aggravation?
Sure, let's use an example. Consider the case where the injured worker has a chronic low back condition, but is still able to continue working. One day while at work and lifting a heavy object, she experiences an immediate onset of severe pain in the low back. That's considered an aggravation because the symptoms of her chronic low back condition became worse or in some ways different.
All right, so in that case, what should that injured worker do specifically?
Well, of course, the first thing for the injured worker to do is to get medical attention because the doctor's opinion is really going to determine whether there's an aggravation of the prior condition or whether it's a new injury. For example, if the prior low back pain was due to an injury at L4, L5 in the very bottom of the spine, and the new injury resulted in involvement of the discs at L1, L2, or L3, that's a new injury. But if the new injury also resulted in aggravation of the L4 and L5 discs, that would be an aggravation.
Okay, so should the injured worker file a new claim if there's an aggravation to the old injury?
Yes, certainly a new claim must be filed if the prior chronic low back condition or prior condition was not the result of a workplace accident. However, even if the old injury was the result of a workplace action, Fine Olin and Anderman will file a new claim. This is for several reasons. First, in most cases, the wages of the injured worker are higher at the time of the new accident than they were at the time of the old accident. So by filing a new claim, the injured worker will be entitled to greater weekly lost wage benefits. Second, if the old claim was subject to the statutory cap that limits how long an injured worker can collect disability benefits, by filing a new claim, the cap starts over again for the new case. Lastly, for those workers who may face termination from their employment because they've been out of work for a certain period of time, filing a new claim starts the clock running on how long before the employer can terminate you.
All right, so when filing the new claim, should the injured worker disclose their pre-existing condition, or how should they approach that specifically?
Well, they have to disclose the prior condition or the prior injury. The C3 claim, which is the form that's used to file a workers' compensation case, has a question that says, have you had another injury to the same body part or similar illness? Do not skip that question. Failure to answer the question honestly, or even worse, giving a false response to the question, will be considered fraud. The obligation to disclose the pre-existing condition or pre-existing injury also extends to the history that you give to your medical providers. So it's important that when getting treatment for the new injury, you make sure your medical provider knows that you had a prior injury to that same location. That obligation also extends to what you tell the independent medical examiner who may examine you on behalf of the employer or their insurance company. Failure to do this could result in a finding of fraud, which would result in permanent disqualifications for lost wage benefits. So it's very important that you fully disclose any pre-existing condition or illness.
And well, it sounds like it, absolutely. Moving on, could you specifically describe what apportionment is?
Yeah, apportionment is a finding by the board that liability for the claim should be divided between the pre-existing condition and the new injury. The general rule is that for apportionment to apply, the claimant must be found to have a disability in a compensation sense at the time of the new injury. However, if the injured worker has been able to work with the condition, the pre-existing condition, then apportionment will generally not apply. If apportionment is found to apply, the board will make a determination as to how much of liability for the current disability should be given to the pre-existing condition and how much to the new accident. So that finding can be 50-50, could be 90-10, or any percentages that add up to 100%.
All right, so just to be clear, for example, if someone injured their shoulder 15 years ago when playing high school football, but re-injures that same exact shoulder while lifting a ladder at work today, could they still file a claim?
Absolutely. They would be covered under the law and entitled to receive medical and lost wage benefits for the new injury. The workers' compensation law is very fact specific, so there's no one rule that applies to every case. That's why it's really important to consult with an attorney.
Okay, so are there any other requirements an injured worker should be aware of, what they should do?
Yes, as in every workers' compensation case, there's strict time deadlines that must be followed. The first one is you need to notify the supervisor within 30 days of the date of the accident that you are claiming an injury from an accident at work. In addition, you have 2 years from the date of accident to file a claim with the Workers' Compensation Board, which is done by filing that C3 claim that I previously mentioned.
Absolutely, and the doctor that they see must be a workers' compensation doctor, right?
Absolutely. If the doctor asks you for a copay or is not sure how to report the results of the physical examination, you should find a different doctor.
That's right. Well, that's about all the questions that I have today. If anybody has any questions or concerns, please feel free to give our office a call, 1-800-522-9001, or head to our website at www.foalaw.com. That's 1-800-522-9001. or foalaw.com. Keep an eye out for additional videos and check out our channel to view more topics that we would like to cover for you to make things a little bit more clear. So thanks for your time today, Howard.
Thank you. And we appreciate you watching this video. We hope you learned something. And if you have any questions, we'll be happy to answer them for you.
Perfect.
So long.